I need you to do something for me, right now. Look at your right hand. Go ahead, look at it. That hand can sign your name. And in this country, that signature is power. It moves your money. It sells your house. It pays your bills. It tells a hospital what you want. Every dollar you control through that signature. Now, I want you to imagine one specific morning. The hand still works. The name is still yours. But a doctor has written one sentence in your chart. A sentence about your memory, or a stroke, or a diagnosis with a long name. And from that morning forward, your signature no longer counts. Not legally, not at your bank, not on your own accounts. Now here's the part I need you to hear, while you are still looking at that hand. On that morning, your husband or your wife cannot sign for you. Let me say that again because almost nobody believes it the first time. Marriage grants zero authority over accounts and property in your name alone. 50 years of marriage grants zero authority. Your children cannot sign for you. Your best friend cannot. Your pastor cannot. On that morning in the entire United States, exactly one kind of person can be given control of your money: a judge, in a courtroom, in a public proceeding with your name on it, that your family must hire lawyers to enter. That can cost them thousands of dollars before they are allowed to pay your electric bill with your money, unless 4 specific documents exist with your signature already on them, signed while that signature still counted. 4 documents. Most cost little or nothing. Some are free at your own bank. And together they decide one question. If the morning comes, does your family take care of you, or does a court take custody of everything you own? My name is Kevin. Today I am giving you all 4 documents. What each one is called, what each one does, the trap inside each one that makes people think they are covered when they are not, and the exact order to put them in place. This is the least discussed subject on this entire channel, because nobody enjoys thinking about it, but it is the one video where doing nothing does not cost you a tax bill or a fee. It costs you the pen itself. If you are new here, subscribe now. This channel exists to explain the rules that decide what happens to your money before the rules decide for you. 2 things to hold before we start. First, near the end, I will tell you about an industry of court-appointed strangers who are paid out of your savings to manage your life. It is legal, it is growing, and it is the exact machine these 4 documents keep you out of. Second, the deadline on this video is different from every other deadline I have ever put on a thumbnail. And when I explain it, you will understand why this one cannot be pushed to next year. Let us start with the morning itself, because the trap only makes sense once you see how ordinary it looks. Let me tell you about Roy and Dolores. Roy is 76, Lincoln, Nebraska, 40 years as a crop insurance adjuster, married to Dolores for 51 years. Roy handled the money. That was the arrangement. Not because Dolores could not, because that was how their generation split the work. The retirement account in Roy's name, the certificates of deposit in Roy's name, the main savings in Roy's name. Their checking was joint. Everything else was his signature. The system worked for 51 years. There was never a single day it failed them, which is exactly why there was never a single day that forced them to fix it. Last October, Roy had a stroke. It was a Tuesday. He was salting the front steps. Jep, he survived, thank God. But the stroke took his speech, and, in the language the hospital used, his capacity. Jep, Roy could no longer legally sign, could no longer legally consent, could no longer legally authorize anything. Jep, and 11 days later, Dolores stood at their bank, the bank they had used since 1979, and asked to move money from Roy's savings to cover what the insurance would not. Chet, the banker, was kind. The banker had known them both for years, and the banker said the sentence that this entire video exists to warn you about. I am sorry, Dolores. You have no authority on this account. 51 years of marriage, standing in front of their own money, with no legal right to touch it. Dolores did what anyone would do. She said, I am his wife. And the banker, who was right, said, the account is in his name. Without a power of attorney, only Roy can authorize this. And Roy, legally, is no longer able to. There it is, the whole trap in 2 sentences. The one person who could grant Dolores authority was the one person who could no longer grant anything. The document that would have fixed this takes about an hour to put in place. Roy was a careful man. He simply never knew the hour was required. Dolores had exactly one road left, and it ran through a courthouse. For 8 months while the petition crawled, Dolores ran a 51-year household out of the one joint checking account, the only money her signature could still reach. She let the CDs sit. She let a repair wait. She borrowed quietly from a daughter, for the first time in her adult life, a woman with plenty of money, living like a woman with none, because all of it was 6 inches on the wrong side of a signature line. We will walk the courthouse road in a moment, because you need to see where it goes. But first, pause with me, because I know who is watching this. Half of you are the Roy in your house, the one whose name is on everything, and half of you are the Dolores, the one who would be standing at that counter. Whichever one you are, the document list in this video is not optional information. It is the hour that keeps your family out of that courthouse, and it is exactly why the quiet rules exists. Everything in this video is in it. The 4 documents in plain English, the questions to ask before you sign each one, the exact sentence to say at your bank, written down in large print. Because this is the one subject where, if the day ever comes, nobody in your house will be in any condition to remember a YouTube video. The paper remembers for you. That is the entire point of paper. Get your copy. The link is in the description below. Or scan the QR code on your screen right now. It takes about a minute, and it goes in the drawer your family already knows about. 7-day guarantee, always. Now, the courthouse road. Because you cannot feel the value of 4 documents until you see the machine they replace. When a person loses capacity and no documents exist, the legal remedy is called guardianship. In some states, conservatorship. Here is what those gentle-sounding words actually mean. Your family must petition a court to have you declared legally incapacitated. Read that again. Their first required step is to publicly argue in front of a judge that the person they love can no longer manage their own life. There are filing fees, there is an attorney for the family. There is often a separate attorney appointed to represent you, paid for out of your money. There are doctor evaluations, court investigators. In many states, a bond, like an insurance policy, that your estate also pays for. By the time a routine, uncontested case is done, families commonly spend several $1,000s. A contested case, where relatives disagree, can burn $10,000, $20,000 and more. Out of the savings the whole fight is about, and that is only the entrance fee. Because guardianship is not a decision, it is a lifestyle. Supervised by a court, the guardian must file inventories, annual accountings, receipts, petitions for permission. In many arrangements, selling the house needs court approval. Moving investments needs court approval. Large gifts to grandchildren, the kind you have made freely your entire life, need court approval. Your checkbook develops a supervisor, and the supervisor bills by the hour. And understand how far the word guardianship can reach. Depending on the state and the order, a full guardianship can remove the right to sign contracts, the right to decide where you live. In some states, the right to marry. In some, even the right to vote. Not because anyone is cruel, because the law, once it declares a person incapacitated, is thorough about it. And every filing in that case, the doctor's letters, the family's arguments, the list of everything you own, becomes part of a court record. A private life made paperwork. Now the part that should genuinely unsettle you. Who does the court appoint? Usually a family member. Usually. But when family members fight, or live far away, or the judge has concerns, courts appoint professional guardians, strangers, licensed, court-approved strangers, who manage the lives and money of dozens of people at once, and are paid hourly from those people's savings. There are documented cases across this country of professional guardianship going horribly wrong. Estates drained by fees, families locked out of decisions, homes sold over relatives' objections. I am not telling you that is the normal outcome. Most guardians are decent people doing a hard job. I am telling you the system has that door in it. And once you are inside the system, your family does not control which doors open. And here is the fact that closes this section. Guardianship is very hard to undo. Capacity, once ruled away, must be proven back by the person the court already decided cannot manage. It happens. It is rare. And the meter never stops. Year after year, the accountings are filed, reviewed by attorneys, approved by the court. And every hour of that review is billed to the estate being protected. A guardianship does not cost something once, it costs something forever. For most people, the day the gavel falls is the last day the money answers to the family instead of to the court calendar. Let me show you what this looks like when there is no Dolores standing at the counter. Edith is 81, Roanoke, Virginia, widowed 9 years, 2 sons, one in Seattle, one in Atlanta. Edith taught 4th grade for 33 years. Half of Roanoke learned cursive from her. Her own signature was a small work of art. 2 years ago, Edith's memory began to slip. Bills doubled up. The gas got shut off once. A roofing crew she did not remember hiring cashed a check for $9,000. Her sons did what loving, distant sons do. They flew in, they panicked, and they discovered there were no documents, no power of attorney, nothing. Their mother could no longer validly sign one. Her window had closed quietly, somewhere in the previous 2 years, without a single ceremony marking the day. So they petitioned for guardianship. And then the machine did what the machine does. HIPAA, the brothers disagreed about her care. Seattle wanted her moved west. Atlanta wanted her home with aides. The disagreement in a courtroom became a contest. HIPAA, 2 sets of lawyers. A court-appointed attorney for Edith. Evaluations, continuances. HIPAA, 14 months. HIPAA, and because the sons were at odds, the judge appointed neither of them. A professional guardian took over Edith's finances. HIPAA, a woman Edith had never met. HIPAA now approved her groceries. HIPAA, the legal bills and guardian fees. HIPAA consumed over $40,000 of Edith's savings in the first 2 years. HIPAA, her sons are good men. They loved their mother the entire time. Every dollar of that $40,000 and every month of that 14, HIPAA was the price of 4 missing signatures. HIPAA, so let us put the signatures in place. Document 1, the most important piece of paper in this entire video. HIPAA, the durable power of attorney. A power of attorney is a document where you, while healthy and clear, name a person you trust to act on your finances if you cannot. Your agent, usually a spouse first, then an adult child as backup. They can pay your bills, manage the accounts, deal with the insurance company, keep your life running, without a courtroom ever hearing your name. Now the single most important word, durable. A basic power of attorney, the kind people sign for a real estate closing, automatically dies the moment you lose capacity. Think about that design. The ordinary version of this document shuts off at the exact moment it is needed. The word durable, written into the document, is what keeps it alive through incapacity. No durable, no protection. Check the actual document, not your memory of it. Second trap, the springing power of attorney. Some documents are written to spring into effect, only when doctors certify incapacity. It sounds prudent. In practice, it can mean your family chasing physician letters for weeks while the bills bounce, arguing with institutions about whether the spring has sprung. Most attorneys who do this work every day prefer a document effective when signed, held by an agent you trust completely. Because the entire value of this paper is speed. And the third trap, choosing the agent. This is a trust decision, not a fairness decision. Do not name 2 children jointly to avoid hurt feelings. If those 2 children have not agreed on a restaurant since 1994, name the one who is good with money and paperwork. Name the other as the backup. A power of attorney built for family harmony, instead of for function, rebuilds Edith's courtroom with extra steps. And now let me answer the objection. That stops more people from signing this document than any other. I am not ready to hand over control of my money. Good, because that is not what this document does. A power of attorney takes nothing from you. You keep every account, you keep every decision, you can override your agent any day of the week, and you can revoke the entire document with a signature anytime you remain capable. It is not a transfer of power, it is a spare key. Cut now while the locksmith still recognizes you and kept in a pocket you chose for a door you hope never sticks. And if trust worries you even slightly, build the safeguards in. Require your agent to share records with the family. Name a second person who must co-sign for any transfer above a number you pick. An attorney can write those rails into the document in 15 minutes. A power of attorney with rails is still 1,000 times faster than a courtroom. Cost of this document. Many states publish a free statutory form. Legal aid offices help seniors with them at no charge. An attorney-drafted version, tailored to your state, typically costs a few $100s. Hold that number against Edith's $40,000. That is the whole argument. And one instruction I want to make unmissable. Both of you sign one. Every example in this video happens in both directions. Dolores needed authority over Roy's accounts. But if the stroke had chosen Dolores instead, Roy would have stood at a different counter, blocked from whatever carried her name. Incapacity does not check whose name is on more paperwork. 2 spouses, 2 documents, same afternoon, same notary, 1 trip. Boom. Now, pause, because I want to say something directly. To the person watching this, who has known for years that this document was missing. Boom. You have thought about it before. Somebody mentioned it at a funeral once. You nodded, and you meant to, and life kept moving. Boom. This video is the reminder that arrived in time. The next reminder might not be. Boom. The Quiet Rules has the full walkthrough, the durable language to look for, the agent choosing questions, the one-page checklist for all 4 documents, in the order that gets them done in a single week. Boom. People do not buy it to read on the couch. They buy it to put the week in motion. Boom. Get your copy. The link is in the description and in the pinned comment at the top. Or scan the QR code on your screen right now. 1 tap. 7-day guarantee, no questions. Boom. Document 2. The one nobody tells you about. Until a bank teller rejects document 1. Here is a secret from inside branch banking. Banks do not love outside powers of attorney. A perfectly valid, attorney-drafted, notarized document can sit in front of a branch compliance department for days or weeks of review. And banks are famous for one particular objection: staleness. If your power of attorney was signed 12 years ago, some institutions hesitate to honor it. Is it still current? Was it revoked? Is there a newer one? The law may be on your side, but the law being on your side does not pay the electric bill this Friday. Hazel learned this standing at a counter. Hazel is 78, Billings, Montana. Her husband did everything right, a durable power of attorney, drafted by a lawyer, naming Hazel as his agent, signed in 2009. When his dementia progressed last year, Hazel brought that document to his brokerage. They did not say no. They said, "We need to review this. Our legal department will contact you." 19 days. 19 days of review, while a document that was valid the entire time sat in a queue. 19 days of Hazel covering his expenses from her own smaller account. Valid is not the same as accepted, and accepted is not the same as accepted quickly. So here is document 2, and it is barely a document. It is a habit. Every major bank and brokerage has its own internal power of attorney form, their paper, their format, already blessed by their own legal department. Walk into your bank, together, while you are both well, and say one sentence. We want to put your institution's own power of attorney form on file for our accounts. Because here is the difference. An outside document gets reviewed, their own form gets processed. Same protection, none of the 19 days. Hazel, by the way, got there in the end. The brokerage honored the document. They always were going to. But she now keeps, stapled to the original, a short letter her attorney calls a certification, a current, dated statement that the power of attorney remains valid and unrevoked. Institutions relax when the paper looks maintained. A living document gets processed, an old one gets studied. And 2 smaller habits that belong in the same visit. First, refresh. If your power of attorney is more than 4 or 5 years old, consider re-signing a current version. A fresh date is the cheapest cure for the staleness objection. Second, while you are standing there, add a trusted contact to every account. 1 name, 1 phone number. They get no access and no control. They are simply who the bank calls when something looks wrong. Free, 2 minutes. Done in the same visit. Quick pause. If this video has already shown you a gap in your house, do 2 things. Subscribe, because next week I am covering what happens to a home title when one owner loses capacity and the sale half of America does not know becomes impossible. And drop your state in the comments, just the state name. Power of attorney forms are state-specific, and the states that show up most under this video, get the detailed walkthrough first. Document 3, the medical twin. Everything so far has been about money, but incapacity has a second front, the hospital. Two papers guard it, and they do completely different jobs. The first is the healthcare proxy. Some states call it a medical power of attorney, or a healthcare surrogate designation. It names the person who makes medical decisions, when you cannot, which treatments, which facility, which doctor. Without it, hospitals follow a default list written in state law, and that default list does not know your family. It does not know that one child shares your values, and another has not called since Easter of 2019. The law just reads the list. Naming your proxy replaces the state's guess with your choice. The second paper is the one almost everyone forgets, the HIPAA release. HIPAA is the federal medical privacy law. It is why a hospital cannot discuss your condition with anyone you have not authorized, and it is enforced even against your own children. Picture your daughter calling the hospital from 2 states away, the worst night of her year, and the nurse, following federal law, saying, "I am not able to share information about that patient." She is not being cruel, she is being legal. The HIPAA release is 1 page. It lists the people your medical team may speak to. No decision power, just information. Sign it once, name your people, and the worst night of your daughter's year at least comes with answers. Dolores, from the start of this video, lived the difference between these 2 papers. Roy had no healthcare proxy either, so while the money question crawled through court, the medical questions defaulted to state law. State law happened to pick Dolores. The spouse is first on most default lists. She was lucky in the one place the law guesses well. But when her son called the hospital from Omaha to ask how his father's night had gone, the nurse could not tell him. No release on file. He drove 90 minutes to hear a sentence. 1 signed page would have delivered by phone. Document 4. The instructions. The living will, also called an advance directive. The proxy from document 3 decides who speaks for you. The living will tells them what to say. Your wishes written down. About machines, about feeding tubes, about comfort care. The decisions no family should have to guess at. Around a hospital bed at 2 in the morning. I will not tell you what to write. That is between you, your faith, and your family. I will tell you what the absence of it does. The absence of it takes the hardest question a family ever faces and hands it to the people who love you most with no instructions. At the worst possible hour, with every relative holding a different memory of something you once said at a Thanksgiving table. Families have been split for a generation over that missing page. Write the page. Most states offer free advance directive forms. Hospitals hand them out at no charge. It costs nothing but 1 honest evening. And spend the evening out loud. Do not just sign it and file it. Tell your proxy what the page says and why. Because a proxy who heard you say it stands steady in that hallway. A proxy who is reading your wishes for the first time under fluorescent lights at 2 in the morning carries doubt for the rest of their life, no matter what they choose. The document protects your wishes. The conversation protects the person who has to carry them. Those are the 4. The durable power of attorney, the bank's own form, plus the trusted contact, the healthcare proxy with the HIPAA release, and the living will. Now the deadline, because I told you this one was different. Every other deadline on this channel is a date, a tax year, a filing window. This deadline is a diagnosis. These 4 documents share one requirement: legal capacity. You must understand what you are signing on the day you sign it, which means the window closes, not on December 31st, but on the day a doctor writes a certain sentence in a chart, and nobody receives that date in advance. Roughly every minute of every day in this country, another American develops Alzheimer's. Strokes arrive on no calendar at all, and unlike every deadline the IRS ever printed, this one gives no notice as it passes. Edith's window did not slam, it drifted shut, somewhere between a forgotten bill and a strange roofing crew, across months when she still seemed fine at church, still beat her sister at cards, still signed her beautiful 4th-grade teacher signature. There was a last day she could have validly signed. Nobody knows which day it was. Nobody ever does. For hundreds of thousands of families, the window will close between now and January 2027, quietly, without a ceremony, the way Edith's closed. That is why the date is on the thumbnail, not because a law changes in January, because for some of the people watching this, and there is no way to know which ones, January 2027 is on the far side of the window. Sign while signing is easy. That is the entire law of this video. And one piece of hope stated carefully for the family already living with a diagnosis. A diagnosis is not automatically a closed window. Legal capacity is about understanding the document on the day it is signed. In the earlier stages of memory disease, many people remain fully capable of that, and attorneys who work with elder families handle exactly this situation every week. If there is a diagnosis in your house, the answer is not despair. The answer is speed. Call an elder law attorney this month, not after the holidays, this month. The window narrows. It has not necessarily closed, but nobody can tell you the date it will. And before the warning and the checklist, one exercise for every couple watching together. I call it the counter test. Tonight, take a piece of paper and list every account and asset in the house. Next to each one, write whose signature controls it. His IRA, her savings, the CDs, the brokerage, the truck title, the house deed. Now cover the page one name at a time and ask the question this whole video is built on. If this signature stopped counting tomorrow, could the other one of us run this household? Every line where the answer is no is a line where one of you is currently scheduled to be Dolores. That page takes 20 minutes. It is the single clearest picture of your exposure that exists anywhere at any price. And add one modern line at the bottom, the phones and the passwords. So much of a household now lives behind logins, the banking app, the email where the statements arrive, the phone that receives the security codes. An agent with a perfect power of attorney and no way past a lock screen still loses weeks. Write the access list, seal it, put it with the documents. Paper authority and digital access are two halves of the same rescue. One warning before the checklist. Because of fear this reel attracts salesmen this fast. There is a circuit of dinner seminars, free steak, free slideshow, where the 4 documents in this video are used as the opening act. For $3,000 document packages and insurance products with long surrender schedules. Hear this clearly. Nothing in this video requires a package. Many states publish free statutory power of attorney forms. Hospitals give away advance directives. Your bank's internal form is free. Legal aid programs and your area agency on aging help seniors with all of it at little or no cost. An attorney is genuinely worth a few $100s for a tailored, durable power of attorney. That is real value. A stranger who needs you to sign tonight at the same table where you ate the steak is not selling protection. They are selling urgency. And you now know the difference. And one darker pattern to know exists. In some states, investigations have found professional guardianship operations that petition courts over seniors they found through hospitals and referrals, sometimes over the family's objections. The strongest shield against ever meeting that industry is not outrage, it is paperwork. A senior with a durable power of attorney, a named proxy, and involved family gives a court no vacuum to fill. Guardianship exists for people who left no instructions. Leave instructions. The checklist. 4 documents, 1 week. Monday, decide your people. The financial agent and a backup. The healthcare proxy and a backup. Function over fairness. Tuesday, the durable power of attorney. Attorney drafted if you can. The state's free statutory form if you cannot. Confirm the word durable is in it. Wednesday, the bank visit. Their internal form, on file for every institution you use. Trusted contact added while you are standing there. Full Thursday, the medical pair. Healthcare proxy, HIPAA release, living will. Free forms from the hospital or the state. Full Friday, tell the people. Copies to your agents. Originals in the drawer your family knows. A document nobody can find protects nobody. For 1 week, a few $100s at most. Against Edith's 14 months and $40,000. Against Dolores at the counter. That is the trade. And if a week keeps slipping the way weeks do, put the map where the week can find it. The Quiet Rules holds this entire video in print. The 4-document checklist, the bank sentence, the agent questions, the free-form sources listed, plus every protection from every video on this channel in one place, in large print, in plain English. It is the drawer version of everything I do here. Get your copy while this is fresh. The link is in the description and in the pinned comment, or scan the QR code on your screen right now. 7 days, full refund if it is not worth its place in the drawer. Let me close with a hand. Look at it one more time. Everything you built, it's signed for. The mortgage, the marriage license, 50 years of birthday cards. It has one signature left that matters this much. 4 pages worth. Sign them while the signing is yours, because the alternative signer wears a black robe and bills your family for the introduction. Send this video to the person in your life whose name is on everything and whose spouse would be standing at that counter. You know exactly who they are. And if that person is you, then this video was never really about documents. It is about the difference between 2 mornings. One where your family gathers around you with authority in their hands and grief in their hearts and nothing else to fight. And one where they gather in a hallway outside a courtroom, holding numbered tickets to ask a stranger for permission to love you properly. 4 signatures decide which morning it is. You still hold the pen. That is the entire point of today. If you want me to look at your specific situation personally, email me at kevinexplainsofficial@gmail.com. I am Kevin. Thanks for watching. Do not forget to check the quiet rules at kevinexplains.shop.